information on the screen there for you while you're stretching. It's just roger.mcgowan at washburn.edu. Also, I won't do a tutorial for you tonight in the interest of time, but there's a lot of information on my website, and it's just washburnlaw.edu/Walter. That stands for the Washburn Agricultural Law and Tax Report. Okay, and then you can follow me on Twitter also, at WashburnWalter. There's a lot of material on that website for you. I also do RFD TV every week. I was just on this morning. And 2 weeks ago, I was in the studio in Nashville for a roundtable discussion with Alan Featherstone, who's the chair of the Ag Econ Department at K-State. We talked about ag policy and tax policy in the new administration and what we might be looking for. That's also archived on my website. Jerry. Okay. That's also archived on my website. If you click on the homepage, there's a YouTube link, and it will take you there also for tax professionals and other professionals, lawyers, attorneys, CPAs. I write a blog. 3 times a week I'll post on that, and then the following week I'll post 2 times. There'll be another post that'll go up in the morning involving a significant Kansas water law decision that came down out of Haskell County at the beginning of the month. This is the second part of a 2-part installment on that. At the law school, there are 3 of us that teach the ag-related courses, of which there are now 9 that students can take. There's no other law school in the country that comes even close to that. I teach several of those. I taught 3 last year, farm income tax and commercial transactions related to agriculture. So that's the bankruptcy and the real estate and secure transactions, and also water and the environment. We also have oil and gas. I'll teach estate and business planning and other courses, civil liabilities and so forth. We just have a slew of course offerings that we can provide for students. And there are big things coming at the law school, and so stay tuned for that. And we do work closely with K-State on a rural law program that we have going with them too. But the topic tonight is fence law, and as Josh said, we do get a lot of questions on fence law. Fences and leases seem to be outside of the tax realm of things, probably the top 2 topic areas that I deal with. And get a lot of questions with respect to those. I try to address some of those periodically on my Every Other Monday show on WIBW with Kelly Lenz, that I'm sure some of you have heard over the years that I do. In fact, I'll be with Kelly in the morning. I'm speaking in Overbrook in the morning to a group of about 150 to 200 producers, and going over the top 10 ag law and tax developments of the past year, which that paper is also archived on the website on the articles page, as is the handout that you have in front of you. It's just a printout of one of the articles that is contained on the website. But if we get into some of the general rules, and I'm going to go sequentially through the article quickly for you this evening, and then we'll open it up for questions. I'm sure that there's always questions with getting defense law and these types of topics, so I want to make sure that we have enough time for that, and then be done by 8 o'clock. Oh, it's 20 after. I'm done. Yeah. Yeah, students would not say the clock is wrong. They would be out the door immediately. But partition fences and location issues, let's start with that. What we mean by partition fence is a fence that's on the boundary. It's on the partition between adjoining properties, and Kansas law says it's to be placed on the line between the tracts of land owned by different persons. Oops, that's the pointer. Okay. Now, it can be located entirely on one side, and that's fine. You can put it not on the actual boundary. You can put it on one side or the other of the line. However, if you do that, that placement of the fence can actually become the legal boundary to the property over a period of time. In Kansas, after 15 years of treatment in a particular location, that can become, by means of a quiet title action, the actual boundary to the property. So while it doesn't have to be on the actual property boundary, if you don't put it on the property boundary, one party might be able to claim that where the fence is actually located is the true boundary, and they might actually prevail on that once you get beyond the 15-year requirement of having used the fence in that location. So that is regardless of what the survey might say. And as I mentioned in the paper, more often than not in rural areas, location of the fence determines boundary more often than does a survey. And I can tell you, when people move out from a town or a city out into the rural area, they don't understand that concept. Yes, back here.
Does that make a difference if property changes hands, if property is sold?
If the property changes hands, is sold, is gifted, is inherited, you can tack on years of prior usage of the fence in that area to your current use to get it to the 15. It doesn't have to be 15 of a particular two owners. It can, one owner or the other can tack on prior usage. The question is whether the fence itself has been treated by the parties on both sides as the boundary. If it's been treated as the boundary for the required 15 years, no matter how you get there, then that can give you the basis for a quiet title action to quiet that title to that line as the boundary. So there are a couple of ways that you can make this 15-year claim. One is called adverse possession. The other one is doctrine of practical location. They kind of are the same, but there's a difference between the two. And so let me go through what the technical difference is, because sometimes it does make a difference. Adverse possession is known as open and notorious use for the statutory period. Now again, in Kansas, that's 15 years. Other states, it might be 2.5 years, or 7 years, or 5 years, or 10 years. It's all over the board. Now in my big book on agricultural law, I list all of the state statutes. I have an actual chart that lists all the state adverse possession statutes. But in Kansas, it's 15 years. In Iowa, it's 10 years. Adjacent, now, open and notorious means the adjacent owners know the fence between their properties is not on the boundary. They know, both parties on both sides know that fence is not on the actual boundary of the property. They know that. And they know where the actual boundary is, but they don't do anything about it. They just treat that as the boundary fence. One person farms up to it on one side or grazes livestock up to it on one side, and the other party does the same thing on their side of the fence. They know that's not the boundary, but just treat it as the boundary. That's why it's open and notorious. Everybody knows where the real boundary is at. Everybody knows that fence is not where the real boundary is. What happens is one party is benefited by the misplaced fence. And typically what happens in this situation is you end up in court after one party's tract changes hands. And now the new owner realizes, oh, that fence is not in the correct location and I'm disaffected by it. I would have more property if that fence were moved where it actually should be. And so they want the actual surveyed boundary to become the boundary. Well, the answer to that is no, the fence is going to end up fixing the boundary to that property if the adjacent owners knew and used it, knew that it was not in the right location and continued to use it as the boundary for 15 years. So you have one party benefited by the misplaced fence, everybody knows where the actual boundary is, everybody knows the fence is not in the right spot, and the other party takes no action to remedy the problem within 15 years. You have all of that, then that fence becomes the boundary. Now, it doesn't automatically become the boundary. You have to go to court and have the court declare it to be the boundary, and that's what I mean by quiet title action. But that's what will happen. Now, a similar doctrine is known as the doctrine of practical location. This is where the adjacent owners know that the fence is not on the boundary, so that's the same thing as adverse possession. But here, the adjacent owners don't know where the actual boundary is. We know that's not right, but we're not sure where the actual boundary is. So you can't have adverse possession because no one is possessing extra property adversely to the other party, because you don't actually know where the boundary is. But one party has a good faith belief of ownership. I think this is mine. And they have a good faith belief. And again, after 15 years of usage, the fence can become the actual boundary between the tracts. So you get the same result. And sometimes you'll see courts say that they got to the result that they did by virtue of the doctrine of practical location. You would read the case, you say, well, that's the same thing as adverse possession. Well, it's the same result. It's just achieved in a different manner. So what I'm saying here is if you have a situation where you don't really know where the boundary is, you can still end up either gaining or losing property after the 15-year statute runs by virtue of this doctrine. Okay, That's the key take-home point out of that. Now, building and maintenance issues with respect to partition fences. So we have a fence, it's in the right location, we don't have a dispute over location, nobody's claiming adverse possession, it's just now it needs maintained. Or we want to, one party wants to put a fence in. So we have building and maintenance issues. General rule again, owners of the adjoining lands must build and maintain in good repair in equal shares unless they agree otherwise. Now that's a key point with respect to the Kansas statute. And I'm going to get into the right-hand rule, left-hand rule here in a second, but the Kansas law requires the owners to share equally in the cost of building and maintaining a fence. And we're going to get into that in just a second. Also, you can enter onto the adjoining land. One landowner can cross over and has a right to enter onto the adjoining landowner's property at reasonable times and in a reasonable manner to maintain the fence. That's not a trespass. And the rule is one of reasonable. Now, it's not spelled out what that means. It's based on facts and circumstances. Obviously, you can't interfere with the activities of the other person. You can't damage crops, those types of things. If you do, you have to pay for that. You can't let their livestock out. Use common sense with respect to that. But at reasonable times and in a reasonable manner, you have a right to work on that neighboring property side of the fence to get your portion of the fence, and I'll define that in a moment what that means, built or maintained. All right. So under the right-hand rule, you'd say, well, how do we figure out who's responsible for what portion of the fence? Commonly, what adjacent landowners do is known as the right-hand rule. And that is they meet at the midpoint of the fence, facing each other, and one party fixes or builds or maintains the fence that's on their right-hand side, and the other party does the same thing on their right-hand side. All right, that's what the right-hand rule means. That is not Kansas law. That's common practice. Kansas law says equal share of the total cost of building or maintaining the fence. Not halves, equal share. Okay. You can have a written fence agreement. They are rare. They do exist. It might not be a bad idea. Get into a written fence agreement with that neighbor. We'll determine who's responsible for what portion, starting at what point, lay out the type of fence we're going to build, and who's responsible for what portion of building and maintaining the fence, record it with the land records in the county register of deeds in the county where that fence is located. That becomes part of the title to the real estate. It runs with the land, and it binds all subsequent owners to that fence agreement. So that's one place to start, is look to see if you have a fence agreement that's on the land records to the tract. That's the first place we tell people to start. Most of the time they'll say, well, no, we don't have one. Okay, then many people will use the common rule of right-hand rule. Again, recognize you can do that. That's not what Kansas law specifies. If you can't come to an agreement with respect to how to build or maintain the fence, we have a couple of other rules that kick in. Kansas is a fence-in jurisdiction. That means that if you own livestock, you have to keep your animals fenced in. Now, you get a couple of tricky things going on here. Usually the question comes up is where you've got one party on one side of the fence that has animals, and one party on the other side of the fence that simply has crops, doesn't have any animals. And so in a fence-in jurisdiction, the one without the livestock doesn't need the fence and may not want the fence. They'll say, it's the other party that has to keep their animals in. Why do I have to pay anything to build a fence that I don't need? They need the fence. I don't need the fence. My crops don't have a tendency to get up and walk away in the middle of the night. I don't need the fence. You build the fence. You pay for your fence. It's your fence. It's not my problem. Not so fast. It is your problem. How so? Okay. What if the adjacent non-livestock owner shares a partition fence? That's the situation I was describing. What Kansas law says is, first of all, if the non-livestock owner doesn't maintain their share, remember their share is an equal share of the total cost. We always start with that principle, whether I have livestock or not. I'm responsible for an equal share of the total cost of building and maintaining that fence. So if I don't maintain my share, and my neighbor's animals get out and cause damage to me because of the defective fence, then I can't recover for my damages caused by my adjacent owner's animals. Okay, that's the first problem I've got if I don't build or maintain my share, even though I don't have livestock. If their animals get out and damage my crops or damage me personally, I have no recourse at law. You'd say, well, that really limits the fence in theory. Yeah, yes, it does. First principle to keep in mind here is that the Kansas fence rules are very pro-livestock industry. They are very old statutes. They go back to statehood. They're very protective of the livestock industry. You have to approach the Kansas fence laws with that in mind. When in doubt, the livestock owner is going to win. Now, that's not always true, but that's a good rule of thumb. Okay. They're also liable to others. Now, what if the non-livestock owner doesn't want their land enclosed? I don't want the fence. I don't want a fence around my property. I don't need the fence, and the big rationale here is I don't want to pay for it because I don't have livestock. Kansas law here reads weird, really strange. What it says is, and you'll notice in the paper, I have full citations to the Kansas code and all applicable cases. So if you need to look any of this stuff up, you know where to go. Also, if you need to give this to your legal counsel, they don't have to do a bunch of research to find all this stuff. It's right there. And that's why that is there. So I'm skipping a lot of that technical detail that we've been pound through with students at the law school. If the non-livestock owner doesn't want their land enclosed, they cannot, Kansas law says, they cannot be forced to build or pay for an equal share of a partition fence. Okay? That seems to run counter to what I just said. Yeah, but I'm not done, I'm not finished with this yet. You gotta read the whole statute. Adjoining tract, to get to that result, to get this conclusion, okay, I don't want the fence, I don't have livestock, it's a fence-in jurisdiction, so I can't be forced to build or pay for an equal share of the partition fence. In what situation? Well, if the adjoining tracts are used in common, and the in common has been defined by the Kansas Attorney General and a couple of Attorney General opinions that I cite in the paper as used for the same purpose. Okay. So if I don't want my land enclosed and my neighbor is using their tract in the same way I'm using mine, in other words, they don't have livestock and I don't have livestock, because if I had livestock, I'd have to have a fence anyway. So this only applies in the situation where I don't have livestock and I don't want a fence. Well, if my neighbor doesn't have livestock either, and he wants a fence, then he gets to pay for it. But once he has livestock, our tracts are not owned in common, and this rule doesn't apply, I have to fork over my equal share. That's what that means. Has everybody got that?